Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
Lordship, please. This is the contempt petition.
Yes.
We expected service on the respondents through email, and on the last occasion, Mr. Thapa was also appearing on behalf of the alleged contemners.
You're appearing for the contemner?
My Lord, so far as my Lord, the service of notice is concerned, my Lord, I'm not aware whether it's been really affected or not.
Very well, since service is not complete, let the matter appear a fortnight hence. Service will be affected individually on the alleged contemners. And an affidavit of service filed. Yes.
Deeply obliged.
Lordship, please.
Item number 2.
May it please your Lordship.
Yes, sir.
This is the income tax appeal, your Lordship.
Yes, sir.
Now, my Lord, 2, 3, 4, 5, my Lord. All these appeals are from a common judgment of the Income Tax Appellate Tribunal.
2, 3, 4, 5, even one. Or 2, 3, 4, 5 are the ones. Yeah, one is the other one.
From a common judgment.
Common judgment.
And my Lord, identical issues were raised. Now, my Lord,
Who is for the department?
Lordship, I am appearing for the department.
You are appearing for the department. Very well.
Lordship.
Your name does not figure on the. Have you disclosed your name to the office?
Yes,
Then they would
I have
print it.
disclosed my name.
Very well.
My name
Yes.
is S.
Yes.
yes. My Lord, here, my Lord, the joint income, my Lord, admittedly, my Lord, that is not disputed by the tribunal. Both the partners, my Lord, are tribals, and their income is generated, my Lord, from the scheduled area. Now, that is not disputed even by the tribunal. They have acknowledged it. Now, my Lord, they sought exemption, my Lord, for the assessment years, different assessment years, on the ground, my Lord, that as per, my Lord, 1026, my Lord, they are entitled
1026 is in the singular.
to single, my Lord. That
1026 is not in the plural.
Lordship,
It's in the singular.
my Lord.
So if you stretch your argument, then you can say if all the tribals together
Lordship.
went into a commercial venture and derived profit out of it, that income would be exempt from tax. That would be absurd.
My Lord,
The individual income
Lordship.
coming to the hands of the individual tribal within the tribal area is what is exempted. And an exemption clause has to be read strictly. It can't be read charitably or generously or in a larger sense.
Your Lordship.
It's an exception to the rule. So it has to be confined to strictly what is said to have been accepted. So
Lordship, yes.
it's a possible view taken by a tribunal which is an expert body,
Lordship.
does not call for any interference in.
My Lord, if your Lordships, my Lord, the opening paragraph. No, opening paragraph, my Lord, it say, if I can take your Lordship to that.
Of the sixth schedule.
No, not sixth schedule, my Lord.
Then?
So far that sixth schedule part is concerned, my Lord, that is, they have admitted, my Lord, the income is from sixth schedule area.
No, that is fine.
Can 26 is say, my Lord, income of a person. So, my Lord, what I am trying, your Lordship, and what I understand, my Lord, the scheduled tribe, what scheduled tribe mentioned in 1026,
Is
my Lord.
person defined in the Income Tax Act?
Yes, your Lordship.
What is a person defined as?
My Lord.
Give us the Income Tax Act.
My Lord, in fact, I have filed 2 paper book compilations, my Lord. All the relevant sections and relevant orders are there. That is 231. Yes. 231, your Lordship. At page
231,
1.
person includes an individual, a undivided family, a company,
A firm.
an association of persons or a body, whether. Now come to the beginning of clause 2
Lordship.
of section 2.
Lordship.
as would be there in any definition section. Every definition section has this provision. In this act, unless the context otherwise requires. So the definition is not all pervasive. The definition is subject to the caveat that unless the context otherwise requires. Now come to 1026.
Law. It's 1026.
They deliberately make this such a complex statute with so many sections and ABC. If they made it simpler, a lot of the cracks wouldn't have been there. But they probably want the cracks because the gravy comes through the cracks. In case of a member of a scheduled tribe,
Lordship.
as defined in clause 25 of Article 366 of the Constitution, residing in any area specified in Part 1 or Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution, or in the states of so and so, so and so, so and so, which you are not covered by, you are covered by the first limb. Any income which accrues or arises to him from any source in the areas or by way of dividend or interest on securities. So what we are concerned for the present purpose is, in case of a member of a scheduled tribe, as defined in clause 25 of Article 366 of the Constitution, so that is, you have to be first a member of a scheduled tribe, B, you have to be residing in any area specified by Part 1 or Part 2 of the table appended to paragraph 20 of the 6th schedule. If you fulfill both conditions, then income which accrues or arises to him will be exempt if it accrues or arises to him from any source in the area. We are not looking at by way of dividend or interest. For the present purpose, that is enough. Now there are two inbuilt things in the provision itself. You have to be a member of a scheduled tribe. No inanimate person, a legal entity which is an inanimate person, can be a member of a scheduled tribe. To be a member of a scheduled tribe, you have to be a human person. Not just a legal entity which is capable of suing or is capable of being sued. Second, you have to be residing in that area. Residing is not having your main office or having your place of business. Residing, the sense it is used over here, coupled with the fact that you have to be a member, makes it obvious that you go out of the pale of the larger meaning of person in section 231 of the Act. That's the simple thing of it.
Lordship. For my contention, your lordships, because these act, my lord, there are various provisions granting exemption, rebate, discount, etc. Now, wherever the intention of the legislature is to confine it to individual income, my lord, they have categorically mentioned individual income, your lordship. I have cited those provisions.
Over here also, it's categorically mentioned in 2026 that it has to be a human person.
No, my lord. My lordship, I understand what your lordship queries are. I'll try to satisfy your lordships. Now, my lord, Now, my lord, if I can just read the beginning of the section 10, my lord, again. In computing the total income of a previous year of any person, any income falling within the following clauses shall not be.
Where are you reading?
My lord, 10. Paragraph 10. My lord, section 10, sorry.
Section 10.
Sorry, section 10.
Sorry.
The book.
Yes. No, just a second.
But I'll just read it.
Yes. In computing the total income of a previous year of any person, any income falling within the following clauses shall not be included.
Shall not be included.
And then you go straight to 26.
Down to 26, my lord. It's it. So, my lord, there are other provisions, your lordships, in the same section, my lord,
Yes.
where exemption or rebate granted to individual income.
Let
I'll
us see.
take, my
Let us
lord, to that. For example, your lordships, section 1026 AAA. What is that? 26 AAA. 1026 AAA.
Yes.
I just read it. In case of an individual being a Sikkimese, any income which accrues or arises to him for any shows in the state of Sikkim, be by way of dividend or interest on securities.
All right.
So, my lord, here, my lord,
Any other?
My lord.
Show all of them and then
Lordship,
proceed with your argument.
This is limited. Section 87A,
87.
my lord.
87A.
87A, my lord. Or shall I just read it? 87A, rebate of income tax in case of certain individual. An assessee being an individual resident in India whose total income does not exceed such and such shall be entitled to
Very well. It's
deduction.
very clearly indicated.
My lord.
It's a
My lord. So, my lord,
It's a clear indication of that.
lordship. So, my lord, here what I want to say, my
Any
lord.
other? Any other?
50? Section 54. 54, my lord. Section 54. 54(1).
Section 54.
My lord. Profit
This
and
is the capital gains.
lordship. Subject to the provision of subsection 2, where in case of SSC being an individual or Hindu undivided family,
Very well. It's very well.
so here. Similarly, your lordship, 54F1. Where is 54F? 54F1.
Fifty-four capital F.
Capital F. lordship. This is also, my lord, capital gain on transfer of certain.
Just a second. Yes.
Yes. So, my lord, these are the sections.
These are the only ones.
My lord, these
No
are
others.
The, yes, these are the ones. No, my lords, wherever the intention of the legislator to restrict it to individual, my lord, they have categorically mentions. But this is absent, my lord, in 1026. So, my lord, my humble submission. Now, other thing your lordship says plural, my lord. The General Clauses Act says, my lord, it can be, my lord, depending on the situation, it can be plural as well, can be read as a plural.
Yes,
My lord.
but you know the problem is that
Lordship.
sometimes when I can very easily prove to you 1 is equal to 2.
Lordship.
But that is after suspending my reason. When you come to a convoluted explanation going from Rome to Germany to Paris to Australia, ultimately to come to Delhi, you lose a lot of reason on the way. There's a very simple explanation to this. Your 1026 AAA came after the annexation of Sikkim, 75. 1026 was there from the 2061 Act. And so that if it would have read better if 1026 was amended and made to read individual, but 1026 was there from 61. So that there is no confusion, these subsequent amendments, all of them that you showed are by amendments, not in the original Act. In amendments, a policy decision was taken to make it more specific by calling them individuals and not persons, so that, but the fact that 1026 remains a person does not detract from the fact that the definition of person excludes the application of the definition if it is not in consonance with the context. We don't know what the tribunal has said. We look at what the tribunal has said. This is not.
No, my lord. In fact,
Yes.
these issue came up for consideration. My lord, other forum it has never been decided. 1026.
Yes.
Except, my lord, one case that is also pertaining to, my lord, Meghalaya concerning the scheduled tribe of Assis, my lord, Mahari and Sons. That was way back in 1992, my lord. And that point of time, my lord, a scope of reference was available under the Act, reference to the High Court. A reference was made to the High Court. Whether, my lord, if a Khasi individual, my lord, generating his income from the scheduled area will also be entitled, my lord, if he joined with other family members, my lord, and makes the earnings. So that was referred to the division bench, my lord, and that was a decision taken by the division bench of the Common High Court in 92. Now, my lord, division bench, my lord, after looking into the provision, my lord, and they have also referred to this person. They have seen since this word person, otherwise individual would have been issues. And ultimately, my lord, the reference was answered that even if, my lord, they come together, my lord, they are entitled to exemptions. That's lordship to that also.
That's a Guwahati High Court judgment.
Guwahati High Court. This is pertaining to Shillong.
Yes.
My lord. So, my lord, if I can take your lordship to the findings now.
Yes.
So these are the basically, my lord, at the time of admission of this appeal, my lord, two substantial questions of lower form framed. One is, my lord, whether the farm by the tax exempt tribals.
Let us see. What were the questions?
My lord.
When was it admitted?
My side.
Whether
Yes,
ITAT
by
in law in denying the benefit of exemption on 1026 to the appellant firm, even though both the partners are members of the scheduled tribe residing in the tribal area specified in Part 2, whether the ITAT was justified in not following the ratio of the judgment in Mahari.
this is the two.
Very good.
These are the two issues.
Let us see the findings.
Findings. The paper book. Other paper book. My lord. That is, my lord, after discussion of the facts, my lord, the finding starts from page 91.
Just a second.
Page 91 of the paper book.
Just a second, sir.
My lord, in fact, there are two paper books. One is paper book containing, my lord, the indexed and list of dates. It is in the indexed and list of dates.
We are looking at ITA 1.
My lord, one.
Yes, sir.
One.
Page?
Paper book, my lord, page 91.
Paper book, page 91.
The finding starts from there.
So there is also a compilation that you've given.
Yes, my two compilations, my lord. One containing, my lord, the various orders, and other, my lord, the relevant extracts of various sections.
Anyway, whatever you cite to us, please. Yes, sir.
Just these are the findings, 91. Paragraph 9. Learned authorized representative vehemently contends during the course of a hearing that both the lower authorities have erred in law as well as on facts in holding that this SSC, a registered partnership firm, is not entitled for Section 1026 examination under provision of the Act. He submits that SSC's both partners are very much eligible for the impune exemption. They could have continued to carry on very relief in case of income in issue would have been treated to have accrued in their individual hands. It is time and again emphasized that both these partners are members of scheduled tribe defined under Article 366 of the Constitution, and that the impugned relief would also have been extended to them in the status of body of individuals qua this income arising to a scheduled tribe's member since accruing them in the specified tribal area. Learned authorized representative next quotes Section 1026 of the Act that the same applies in case of competition of total income of any person of a previous year who is member of the scheduled tribe than to an individual SSC only. His case is that legislature has nowhere used the clinching expression individual category of SSC alike that under Section 1026 AAA, Section 87A, Section 54(1), and Section 54F(1), etc. Learned counsel contends that wherever the legislature has intended to restrict the impune exemption benefit, it has made it explicitly clear in the relevant legislation, culminating in various statutory provisions, and that such a restrictive interpretation of Section 1026 would tantamount to putting the provision itself stricter to liberal use only. Our attention has been invited to the coordinate bench decision of CIT versus Mahari and Sons that the legislature has deliberately not used the expression individually in Section 1026 and has employed the word person, which is wide enough to include in its ambit the unit as that of Khasi family, as in the present case. Honorable Guwahati High Court's decision has discussed the issue as under. Viewed thus, it is difficult to say that the benefit of exemption from income tax given under Section 1026 to a member of Khasi tribe will cease to be available if such income accrues not to an individual member but collectively to a number of such members known as family. It must be remembered that Section 1026 is a beneficial provision intended to provide protection to members of the scheduled tribes from the burden of income tax. The benefit is confined to tribal people residing in specified area, and that too is available only in respect of income accruing or arising to them from any source in such areas. Thus, whatever limitation the legislature wanted to put, it has specifically incorporated into clause itself. No more condition or restriction can be added, nor can such beneficial provision be given too narrow a meaning, which may result in disentitling the member of Khasi tribe from the benefit conferred by this clause. The SSC next refers to Section 13 of the General Clauses Act 1897 that in all central acts and regulation, unless there is anything repugnant in subject or context words imparting masculine gender, also include feminine gender, and words in singular shall include plural, and vice versa. Its case therefore is that legislative expression member used in 1026 Act included members as well. And since the SSC firm income is the joint income of eligible scheduled tribe members, partners already enjoying exemption, and that it is also entitled for the very relief as necessary corollary. It is re-emphasized with the Honorable Guwahati High Court has already held that the impugned statutory provision is beneficial in nature. Mr. Modi next invites our attention to Section 231 of the Act defining person to include an individual, HUF, a company, a firm, an association of person, or a body of individual, a local authority, and every artificial juristic person not falling under any of the preceding clause. He pleads that the lower authorities have erred in denying the impugned exemption benefit to a firm, thereby creating an artificial definition between body of individual and firm, whereas both of them contains joint income of their members and partners respectively. The SSC next quotes the Honorable Guwahati High Court's decision CAT versus such and such, that a body of individual accruing in Section 231 of the Act means conglomeration of individuals who carry on the same activity with the object of earning income. Its submission is that partnership firm is nothing but such conglomeration of individual only, and that Section 231 of the Act imports definition of firm, a partner and a partnership firm of from the Indian Partnership Act 1932, only meaning thereby partners collectively are taken as a firm. Learned Counsel thereafter referred to Honorable Apex Court's decision in Dulichan, Lakshminarayan, such and such, that a firm's name is merely an expression, only a compendious mode of designating the person who have agreed to carry on the business in partnership. And Commissioner of Income Tax versus such and such also hold that business carried out by a firm is a business carried out by partners, wherein the former's profit are earned by the latter. The SSC's next quotes Section 1026 exemption clause in statute that Honorable Apex Court's decision in Commissioner of Income Tax versus Chidambaram Pillai holds that the statement of law that although the purpose of Income Tax Act, a firm has certain attributes, similitudes of personalities, we have to take that a partnership is not a person but a plurality of persons. Their Lordship yet another decision in such and such holds that firm is not an independent entity, its partners are the real owners of the assets of the firm. The firm name is only a compendious name given to the partnership for the sake of convenience. The assets of the firm belong to and are owned by the partners of the firm. Learned Counsel accordingly contends that the SSC has firmly established that by virtue of Section 231(5).
Yes, you see that. Now tell us something.
Lordship.
Let us say you and I form a partnership firm.
Lordship.
The firm has a PAN number, the firm has to be assessed. So the firm is liable to pay tax. After that, the profits are distributed in the manner provided in the partnership agreement.
Yes.
Are we exempted from paying income tax individually just because the firm has paid the tax?
Yes.
Yes, ma'am.
Yes.
Or do we have to pay tax?
We have to farm.
If the firm has paid tax, partners.
If the farm has paid the tax, well, tax is collected from the farms, then we are not required to pay.
Your profits that you get from the firm.
Lordship.
Yes, sir, your name is still not.
My Lordship, I am S.C. Subhash Chandra Kayal, Lordship.
Mr. Kayal,
Lordship.
the income generated by a firm is taxed.
Yes.
Now, if the profit is distributed by the firm to its individuals, will that be taxed or will that not be taxed?
Lordship, individually they are exempted under Section 1026, Lordship. But as a firm is to be assessed separately.
Oh, under which provision of 1026 is the individual? Partner of a firm.
Partner of a firm, individually they are not, under Section 1026, they are not liable to pay
You
tax.
don't even follow the question.
May I, Lordship? There is a provision called Section 10(2)(a). Under the scheme of the Income Tax Act, there is no double taxation. A portion of the firm's income is apportioned to the partners as salary and interest.
No, not a salary and interest. Let us say a partnership firm has made a profit of, let's say, 10 crore in any financial year,
Yes, Your Lordship.
in any assessment year.
Yes, Your Lordship.
And then, according to the deed, such profit has to be divided equally to the two partners.
Yes, Your Lordship.
All right?
Not so.
Now, will that be taxed in the hands of the individuals?
No, if the firm has paid tax on the total profit, then individuals are not required to pay tax under section 10 clause 2A, Your Honor.
So, to that extent, even under 1026, you will get exemption?
Because that is non-taxable under section 10(2)A, Your Honor.
Yes.
Question of
Therefore, to
1026.
that extent, that benefit you will get, even if you are partners, even if you are scheduled tribe partner, two scheduled tribe persons,
Yes, sir.
if they get together, then you get that benefit also.
Yes, sir.
You get no less benefit than anybody else.
If in case of firm, if it is not taxed, then in the case of partner, it will be taxed under section 28(5), Your Honor. There is no double taxation. If in the income of the firm, if the firm is assessed, then partners are not taxed. But if firm is not assessed, the amount paid to the partners are allowed as a deduction to the firm, then individuals are assessed.
The same goes for dividend.
No, there the separate legal entity or corporate entity is there, Your Honor. They are different persons. So income of shareholders and income of company are of separate nature. Dividend is always taxed as income from other sources. Its source is treated as differently and the company pays tax under the head business income. Whereas in the case of partnership firm, if the firm is allowed deduction, the same income is treated as of the same nature, business income in the hands of the individual partners.
And to that extent, that part of the income of the partner is exempted from.
If it is taxed in the hands of the firm, it is exempted.
exempted.
If it is allowed as a deduction, it is taxable. Your Honor.
Very good. Now, show us the Guwahati judgment, please.
My lord, Guwahati judgment, my lord, will be at,
Yes, you've given us a copy.
my lord, in the paper book, your lordships, the other paper book, your lordship, paper book of relevant extract of laws and citations.
This is 1992 1 GLR.
Yes, yes.
This is at page, my lord, 26.
It's also reported at ITR.
My lord, but then not the entire, my lord, some references. 12,
Yes.
my lord. We start from, my lord, 13. My lord, I just read it.
It has to be confined to a family at the highest.
So far,
Lordship.
body of individual. So far, my lord, only thing, my lord, I am apprising your lordship. So far, this particular case is concerned, farm. This comprise of two partners, my lord, husband and wife, my lord, within the family, husband and wife.
This is a husband and wife.
Husband and wife. And so far, they are tribals, my lord. Those are facts have been acknowledged by the tribunal. Their eligibility otherwise generated, my lord.
In our case, it is a husband and wife.
Husband and wife. Husband and wife. All the four cases, husband and wife. Now, my lord,
Now, let us come back to
Tribunal.
how the tribunal distinguishes the judgment.
Lordship.
Paragraph 17.
The finding starts from, in fact, my lord, in that regard, 94, 17, paragraph 17.
This quotation is at page 97.
Lordship.
Is from where?
This is from the, my lord, what happened in that case, the tribunal ultimately held, my lord, income tax tribunal held that we are entitled, my lord, even the family, if the jointly by a family, they are entitled to exemption. So this is, my lord, reproduced from the judgment of the tribunal. And thereafter a reference was made to the High Court from the same judgment.
Where is this 2 and 2 ITR?
My lord? 202 ITR. My lord, that is Andhra Pradesh High Court decision.
What is this 199 and 2 and 2 ITR? Why 2? Have you given that
We
to
have
us?
given, I think, my lord, we have given in our, this is beer construction, no? Huh? I think we have given in our citation, no? This is, my lord, comes to, equivalent will be a lordship, beer construction, my lord. This will be 1993-1, Andhra Pradesh Law Journal, 63A, High Court. And the relevant paragraph is paragraph 29, my lord.
1993?
1 APLZ, Andhra Pradesh Law Journal. 60. It is there in order. I have marked it.
This is when can one differ from another?
Lordship.
For inquiry.
They tribunals
not
declared
agree.
its amicus
This does not
par
have to
incurium on the basis of this judgment.
Anything else?
My lord, other ground, my lord, the tribunal has cited, my lord, cited one decision of Supreme Court, Mr. What Chaudhary?
Well,
That is regarding, my lord, construction. If exemption notification strictly to be constituted, any ambiguity, my lord, benefit should go to the revenue.
Nowadays, the Supreme Court has even said something else.
Lordship.
Throughout the years, we have learned that if in a taxing statute,
Lordship.
benefit of doubt will go to the SSC. Now the Supreme Court has said no.
It will go to the,
Benefit of doubt may not necessarily go to the SSC. So that old view has been changed. In the context of that, an exemption, forget the taxing statute. Whenever there is an exception, let us say all persons will be whipped, except those who are bald. Which means that if you have one hair, you will still be whipped. It has to be that strictly interpreted. And in any event, even when the previous understanding of the law was that benefit of doubt will go to SSC, but in case of exemption, it will go to the revenue. Now when that principle has been doubted and it says benefit of doubt need not necessarily go to the SSC, then the benefit of exemption will go furthermore in favor of the revenue and will be more constrictively interpreted. There's nothing. The only problem is that the tribunal, is there a thing in the tribunal itself where there is a difference of opinion? Can it be sent to a larger bench of the tribunal?
No, my lord.
Yes, Your Honor.
Can be.
Yes.
Can be.
Yes, yes.
Yes.
We have seen
Can be.
it could be done because over here,
Seen.
two things there in discipline. One is that against judicial decorum. After all, it's a quasi-judicial body. For instance, today, if we were strictly bound by even though that is the parent High Court, we are no longer bound, but if we were strictly bound by that, a division bench cannot disagree. A division bench cannot disagree. Similarly, In the tribunal also, because they are governed by several high courts, there are two principles. If the view is not, the view that you are about to take is not established by any high court,
No, sure.
then you have to agree with the view expressed by coordinate bench. If you disagree with the view of a coordinate bench on which there is no pronouncement by a high court, then you have to refer it to a larger bench of the tribunal. That's number one. Number two, several high courts have rendered different opinions. The opinion rendered by the jurisdictional high court has to be considered. So let us say 20 high courts have rendered different opinions. But the opinion rendered by the 21st High Court is the jurisdictional High Court. Even if that opinion is contrary to the 20 other opinions rendered, you are governed by that opinion. So both these, it was a case of indiscipline. They should have either referred it to a larger, or they were bound. They could have indicated that that is wrong. Similar as we are also required to do. There are several judgments where I have said, not too many people do, but fools like me do, I have said the Supreme Court judgment is wrong. I've even said to the extent it's rubbish. But I've said, but I'm bound by it. I have to follow it. There's a judgment, for instance, pertaining to place of arbitration will decide which court can entertain the challenge to the arbitral award. It's in a constitution bench judgment of Justice Nijjar and everybody else, only the single judgment, in the context of international arbitration. There's a cardinal principle in international law which is distinguished from municipal law. In international law, when you indicate a venue, then unless you qualify it, you also adopt the law of the venue. In municipal law, that principle does not apply because the law that prevails in Delhi is the same law that prevails in Bombay, is the same law that prevails in Calcutta. So there is no choice of law coupled with choice of venue. But that mistake was made in the Constitution bench and has been repeated thereafter. I have said it's completely wrong, and because obiter of Supreme Court is of great persuasive value, but at the end of it, obiter is not binding. But of course, in the present age of sycophancy, not too many fools will do it. They will all say, yes, it's 3 bags full, sir. That's why law does not develop when you get 3 bags full, sir, judges. That's all.
No, that is anything. This is the thing.
Thank you. Thank you.
So other minor, all identical issues, same common judgments.
Right. Finish it, brother. These appeals arise out of a common judgment and order passed by the Income Tax Appellate Tribunal. Where does it begin?
My lord, it starts at page
Case 72, Lord.
By the Income Tax Appellate Tribunal,
72, yes.
Guwahati bench. In proceedings arising under section 255(4)(2) of the Income Tax Act 1961. Paragraph. At the time that the present appeal was received by this court, the following questions of law were framed, set out from order dated February 12, 2020. The following questions of law were framed on February 12, 2020, then set out the two questions. Full stop. In all the matters, they are husband and wife partners.
Yes.
No.
In the case of Central Point, they are,
Lordship, in other cases,
in case of to Central Point, they are brothers.
Brothers, my lord. Two are the center point, it is brothers.
And Rikinjai?
Rikinjai, husband and wife.
Husband wife. So there are two center point matters and two Rikinjai matters.
No, Rikinjai matter, three center points.
Three center point matters. Very good. Of the four matters, of the four appeals, the first pertains to a resort popularly known as Rikinjai, and the three others are in respect of a business entity by the name of Center Point. Full stop. Both SSEs are partnership firms, Rikinjai being controlled by a partnership firm comprising a husband and wife, and Center Point being a partnership firm of brothers. Full stop. There is no dispute that the partners are members of a scheduled tribe and that the business is run within a scheduled tribe area. Full stop. The issue turns on the interpretation of section 1026 of the Income Tax Act of the Act of 1961. Full stop. The relevant provision provides as follows: 10, then the first part, and then ... 26, paragraph. According to the department, whose contention has been accepted by the tribunal, the exemption provision contained in section 1026 of the Act is confined to a sole human individual and cannot be extended to either a group of individuals or to a body of individuals which may, in its compendious form, be capable of suing or being sued. Full stop. Paragraph. The principal grievance of the appellants herein is that In holding as aforesaid, in holding against the appellants, not against the appellants, and observing that the exemption in section 1026 of the Act would not be available to even a partnership firm comprising individuals who were members of a scheduled tribe and the entire income had accrued or arisen within the tribal area, the tribunal disregarded the dictum of the Honorable High Court at Guwahati that was binding on the tribunal, and also differed with a previous view rendered by a coordinate bench of the same tribunal. Full stop. Paragraph. There is some merit in the grievance of perceived judicial indiscipline, and it is such aspect of the matter that has to be addressed before answering the questions framed at the time of admission of the appeals. Full stop. Paragraph. With the burgeoning of tribunals in different fields, bracket, never mind the emasculation of the original court structure, bracket closed, such quasi-judicial bodies are subject to, if not superintendents, the orders and directions passed by high courts, whether in exercise of their constitutional or appellate or revisional jurisdiction. Full stop. In such a scenario, where there are different benches of such tribunal spread over the country and which are subject to the appellate or revisional jurisdiction of jurisdictional high courts, the general rule is that the view expressed by the jurisdictional high court in respect of a particular matter would be binding on the tribunal unless a contrary view in such regard has been expressed by the Supreme Court, whereupon the jurisdictional high court's view would stand eclipsed. However, full stop. However, if a common view has been rendered on a legal position by several high courts without exception, notwithstanding such view not having been expressed by the jurisdictional high court, the tribunal would, by and large, be bound by the common view expressed by the other high courts. Full stop. In case of a conflict of views between other high courts and of the jurisdictional court, in a particular case, the view of the jurisdictional court has to be accepted by an inferior tribunal. Paragraph. As between decisions of coordinate benches of the tribunal, there is a prevailing practice that a particular view expressed by a coordinate bench becomes binding on another coordinate bench, just as it does under the doctrine of precedence to coordinate benches in the High Court and in the Supreme Court, and if a subsequent coordinate bench disagrees with the view rendered on a legal proposition by a previous bench of similar strength, the matter has to be referred to a larger bench. Full stop. This is the same principle as it operates in high courts. Full stop. Paragraph. At the heart of the rule in such regard is the element of consistency, which is the hallmark of an advanced judicial system. Full stop. Once a legal issue has been interpreted in a particular manner, citizens would be expected to abide by the same and act accordingly. Full stop. If a view already expressed were to be lightly altered and subject to change on a regular basis, there would be no consistency and no yardstick for the common citizen to act in such regard. Full stop. It is thus, the element of consistency, rather than the correctness of the decision, which is at the heart of the larger principle of stare decisis. Full stop. Of course, for a judgment to be regarded as stare decisis, it must hold good for a long period of time. Full stop. Paragraph. In the present case, the matter before the tribunal pertain to residents in the state of Meghalaya, which, except for a small pocket in the municipality of Shillong and the cantonment thereabouts, is an entire region covered by the 6th schedule to the Constitution. How does the sentence start? Last, and a decision pertaining to a body of individuals comprising Khasi tribals had been rendered by the then Common High Court which ought to have weighed with the tribunal. Full stop. At any rate, comma, the reference that was answered by the High Court in the judgment reported at what ITR is it?
My lord, this is 1992 1 GLR 125.
What ITR is it? Please sit down, sit down. Sir.
Tax reference number 5. 195 ITR 630 Guwahati.
195 ITR 630 bracket GAU GAU bracket closed. Then cause title I'll give it to you. No, Mahadi is the thing. It's IT something versus Mahadi. CIT versus
Mahari and Sons.
Mahadi and Sons, comma Shillong. Is the sentence complete?
Anyway, the reference that was answered by the High Court in the judgment reported at 1995 at the Archival Data bracket GE, Proceedings, CIT, Mahari and Sons, law.
Bracket close. How does the sentence begin?
In the present case, the matter before the tribunal pertains to the resident in the state of Meghalaya, which.
Very good, very good. For good or bad, comma, the High Court held, the Guwahati High Court held that when a beneficial legislation, when a benefit was conferred to a class of persons, comma, the effect of the benefit could not be read down. Full stop. Paragraph. At any rate, comma, it is evident from the impugned judgment and order dated
7th December 1991.
December 7, 1990.
91.
This one is 1991.
13/9.
13/9/2019.
Impugned judgment and order dated December 13, September 13, 2019, that even the tribunal in the case of Mahari and Sons had extended the benefit of the exemption to a body of individuals claimed to be a joint Khasi family. Full stop. Paragraph. Thus, comma, The tribunal appears to have, a tribunal in this case appears to have erred on 2 counts, It took a view different from the one rendered by a coordinate bench of the same quasi-judicial body, and comma, it did not follow the law as enunciated by the jurisdictional High Court that was binding on it. Full stop. Paragraph. As to when a judicial precedent becomes binding, comma, need not be repeated. Full stop. However, comma, the binding value of a previous precedent is lost upon a forum superior to the one which rendered the previous precedent, holding otherwise on the same legal issue, or the law changing, or it being demonstrably erroneous. Full stop. Indeed, it is in such a scenario that the principle of per incurium comes into play. Full stop. Plainly speaking, comma, the expression per incurium implies, within quotes, in ignorance of, full stop, close quote. A judgment can be said to be per incurium if the view expressed therein is contrary to a provision of law that is not noticed therein, or such view is contrary to a judicial precedent that was binding on the forum but was not cited or noticed. Full stop. Good law is also rendered bad upon circumstances changing and a superior law forum much later expressing a contrary view. Full stop. Paragraph. Strictly speaking, comma, the legal issue that was decided by the bench of the Tribunal of Coordinate Strength and by the Guwahati High Court could not be found to have been per incurium by referring to the Supreme Court judgments that have been relied upon in the impugned judgment and order. Full stop. There can be no dispute that both the previous bench of the tribunal and the Guwahati High Court agreed that when the SSC was a body of individuals, notwithstanding every member of such body being individually entitled to the exemption under section 1026 of the Act, comma, collectively they would also be entitled to the same benefit. Full stop. No other decision of any other High Court, far less the Supreme Court, on the same issue was before the tribunal, in this case, for the tribunal to have taken a view different from the one expressed by the tribunal itself in Mahari and affirmed by the Guwahati High Court in the same case. Full stop. Paragraph. However, upon a consideration of the matter on the merits, the view expressed by the Guwahati High Court does not appeal and appears to be plainly at variance with both the letter of the relevant provision and the meaning thereof. Full stop. This discussion has to be prefaced with the observation that for long the modern jurisprudence that is developed in this country recognized that when it was a taxing or fiscal statute, and the words in a provision led to a form of ambiguity, the benefit in such case had to be given to the SSE. Full stop. Recent judgments of the Supreme Court have doubted such principle. Full stop. On the other hand, it is an established principle, whether in a taxing statute or otherwise, that when an exception is carved out of the general rule, the exception has to be read strictly and a purposive or wider interpretation thereof cannot be rendered unless the plain words admit of the same. Full stop. Indeed, the tribunal in this case noticed Supreme Court judgments to the effect that even though the benefit of a doubt in a taxing statute could be given to an SSE, when there was any doubt in any exemption, the benefit had to accrue to the revenue and not to the SSE. Full stop. Paragraph. For the present purpose, the material part of section 1026 of the Act as relevant in the context may be seen as follows, : 10 full stop. In computing the total income of a previous year of any person, any income falling within any of the following clauses shall not be included, dash, next line, dot, 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 then next line, 26 within bracket. Next to that, small. In case of a member of a S capital T capital scheduled tribe, as defined in clause bracket 25 of Article 366 of the Constitution, comma, residing in any area specified in Part 1 or Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution, ... any income which accrues or arises to him, comma, dash, next line, indent, small a, from any source in the areas, ... next line, b, ... close quote. Paragraph. The operative part of the provision that is relevant for the present purpose, comma, once reduced as indicated above, there are two initial conditions that have to be met for a person to be entitled to the benefit granted thereby, colon, such person has to be a member of a scheduled tribe as defined in clause 25 of Article 366 of the Constitution, semicolon, and that such member of such scheduled tribe would have to be residing in any area specified in Part 1 or Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution. If a person complies with if a person complies with both these conditions, comma, in that event, any income which accrues or arises to him from any source in the areas, meaning the areas specified in Part 1 or Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution, comma, such person would be entitled to the exemption under section 2026 of the Act. Full stop. Paragraph. Much is made of the word within quote person appearing in section 2026 of the Act. As such word is defined in section 231 of the statute. Full stop. Section 231 of the statute provides an inclusive definition and reads as follows, colon, set out. When you set out, you'll first do 2, then 2 full stop. In this act, comma, unless the context otherwise requires comma dash, then ... and then 31, after 31, ... close quote. Paragraph. As is elementary, comma, definition provisions of a statute define particular words used in the statute but there is always a caveat provided in the definition section itself. As in this case, the meaning attributed to the word person in the definition would have to be substituted wherever the word person is used in the statute, provided that the context does not require otherwise. Full stop. In other words, when the context of a provision is such that the meaning ascribed to a defined word would not fit into it, the definition cannot be imported into such provision. Full stop. Paragraph. The test in this case would be to comprehend the kind of person to whom the exemption is extended under section 1026 of the Act. Full stop. For a start, the person, as relevant for the present case, would have to be a member of a scheduled tribe, as indicated. A member of a scheduled tribe can only be an individual or a human person and not an inanimate entity. Further, the second condition in the provision expressly, deliberately uses the word within quote residing. Full stop. Even though, in a larger sense, even an inanimate entity can be said to be residing at where its principal office may be situate, the first condition in the present case requiring a person to be a member of a scheduled tribe, read with the second condition that also requires him to be a resident of a particular region, there is no escape from the fact that the person referred to in section 1026 of the Act has to be a human agency or individual and not an inanimate entity or a collection or body of individuals. Full stop. Paragraph. A somewhat of a murmur is also raised by the SSEs in this case as to gender and number being interchangeable in accordance with the provisions of the General Clauses Act. General Clauses Acts. Full stop. Is there a General Clauses Act state or General Clauses Acts?
Section 13.
Full stop. However, the same caveat as the context applies to the general principle enunciated in the General Clauses Act, and by virtue of the exemption in this case being limited to a member residing in a tribal area, comma, the provision cannot be seen, the provision cannot be taken aid of by a body of individuals or by an inanimate entity, which may even be a partnership firm, which is a compendious form of indicating the partners thereof. Full stop. Paragraph. The overarching consideration in the present case is that the exemption granted by section 1026 of the Act is limited to solitary persons and not extended to bodies of persons. And since an exemption provision has to be read strictly in accordance with the letter thereof, comma, the ambit of such provision cannot be enlarged as was sought to be done both by the tribunal in the Mahari and Sons case and by the Guwahati High Court in endorsing the same. Full stop. Paragraph. The SSEs have referred to several other provisions in the Act to suggest that where the statute confined the operation of a provision to a human individual, comma, it was invariably indicated as individual and the word person has not been included therein. Towards such end, comma, the SSEs referred to section 1026 bracket AAA, 10 bracket 26 AAA bracket closed, comma, section 87 capital A, section 54 and section 54 capital F of the same Act. Full stop. At first blush, comma, it is difficult to miss that all the provisions cited in the context by the SSEs are provisions that have come in long after the statute was enacted and by way of amendments. Full stop. It is possible that the word individual, paragraph. It is possible that the word individual within quote may have been more appropriate than the word within quote person in section 1026 of the Act. Full stop. However, comma, that the word within quote person continues to remain in the provision does not detract from the fact that the word within quote person used in such provision has to be read differently from the definition of within quote person in section 1031 of the Act. Full stop. It may only be conjectured that by way of abundant caution and so that the little ambiguity involved in the use of the word person is avoided, comma, in the amending acts, the word individual has been used in preference to person, full stop. At any rate, comma, in at least two of the other provisions cited, comma, the word individual has been used in conjunction with the typically Indian entity of HUF or Hindu undivided family. Full stop. Paragraph. In fine, comma, therefore, comma, the view expressed by the tribunal to the effect that the exemption available under section 1026 of the Act is to an individual member of a scheduled tribe as indicated, residing in the area as specified, comma, appears to be justified, full stop. It may have been better, comma, though, comma, if judicial discipline had been maintained and the matter may have been referred to a larger bench or, comma, possibly, comma, the view of the Guwahati bench, which was Guwahati High Court, which was binding, was accepted with a note of dissent for the High Court, for the jurisdictional High Court itself to take a call thereupon. Full stop. Paragraph. The questions raised in the appeal are answered as follows. 1. The ITAT Guwahati committed no error in denying the benefit of exemption under section 1026 of the Act to any of the appellant firms, full stop. 2, comma, ideally, comma, the ITAT ought to have deferred to the view expressed by the jurisdictional High Court with its reservation for the jurisdictional High Court to have taken the same into consideration and, comma, if necessary, rectified the same. Full stop. Paragraph. ITA numbers 1 of 2019, 2 of 2019, 3 of 2019 and 4 of 2019 are disposed of. There will be no orders to cause.
Well, the only thing, if I can, just small thing, I should have pointed out. My lord has disagreed with the division bench of Guwahati High Court. But the only thing under the Northeastern Reorganization Act, it says that any judgment pertaining to Shillong, my lord, passed by the Common High Court shall be deemed to be a judgment.
Where is that?
Well, I have referred to that. That is, my lord, Northeastern Reorganization Act, the amendment 28(1). Lordship. 28I.
Section 28.
28I, my lord. Amendment 28I.
Yes, yes.
My lord, will come 22 clause 4, your lordship. Subsection 4, my lord. Any order
on and from day, the High Court of Assessors shall cease to function. There shall be a common, and then?
Then, my lord, 28(1) subsection 4.
28
28(1), 28I, Your Lordship.
I.
28I, subsection 4.
There's no subsection 4.
There is a subsection, my lord, if I'm not wrong. GHI, 28I, my lord. This amendment, Northeastern Areas Reorganization Amendment Act 2012.
Give us don't give us an act which is unamended. If you have a copy, give it to us.
Lordship. So my understanding really is
Let us.
deemed to be a judgment
You could
of.
be right. We don't know. We haven't seen it.
That's my understanding, Lordship. Subsection 4.
Then you should have told us at the beginning. You shouldn't
Lord,
have
I'm sorry,
wasted so
I'm-
much time.
That's
281.
28I, Your Lordship. Alphabet I. 28I, my lord. This amendment is called
28I.
Lordship. Subsection 4.
Any order made by the Common High Court is order defined.
My order is not defined, Your Lordship.
This will be left only to orders. Just cut out the entire thing and type it out and leave it, because that will be what the full bench judgment will be. Type it down and give it. Then write a new order. At the time that these appeals, involving a common question of law, was admitted on February 12, 2020, the following questions were framed, paragraph. Since it appears from the second question itself that the legal issue has been decided by a division bench of the Guwahati High Court in the judgment referred to in the second question, and in view of section 28 capital I of the Northeastern Areas, what is the full
Reorganization Act, my lord.
No, there's a full form of there. Areas, bracket reorganization, bracket close, and other related laws No, it's not 28I of the Amendment Act. Northeastern Areas Reorganization Act 1971, the appeals are referred to a full bench of this court comprising all three present judges of this court. Whose cousin? Necessity, doctrine of necessity. Two of us are there. We'll write it in the beginning and he'll be holding against the appellants. That wouldn't matter. Full stop. Paragraph. Lest such bench be convened a fortnight hence.
Obligation.
And we'll interpret over there.
Lordship.
This will mean only orders, not judgments.
Lordship.
But do the other one and keep it because, and give it to me so that it remains.
Item
Yes.
number 6.
Public.
Sir, we segregate the file. Yours is mixed up with us.
Yes. You're for the appellant?
No. Mr. Mohanto, my lord.
Yes.
Well,
Actually, Your Lordship, can this matter be taken up after the commission case?
my lord, in fact, there is an order
Yes.
to, my lord, list this matter after disposal of the Kamarchand case, my lord.
Yes.
So Kamarchand is coming up on 17th for judgment, my lord.
Judgment is already ready, so that.
It's up to, I have no problem, my lord. It's up
Very well. Since previous orders on this matter required criminal appeal number 1 of 2020, bearing common issues, to be decided first, let this matter appear next week.
My lord,
Since-
after 2 weeks, my lord,
Yes.
I may have some difficulty.
Let this matter appear a fortnight hence, since judgment in criminal appeal number 1 of 2020 is scheduled to be delivered on February 17. There are two matters or one? Yes.
From the main list, item number 1.
My lord, item number 1 involved, my lord, the application file for condonation of 3,000.
Where is that application?
My lord, may I come to? Lordship, may kindly come to page number 38. 38, my lord. He was seeking for, my friend was seeking for, my lord, condonation of my lord.
It's a suit.
Suit, my lord.
Oh, substitution.
Substitution,
My lord.
Plaintiff died in 2011
My lord.
and application was made in 2020.
2020. And the only ground they have taken is, my lord, para 7, the next page, 14.
Where is the provision for limitation?
My lord, 90 days only.
Where do you get that provision?
My lord, that is a Limitation Act, my lord, section 120. Yeah, Article 20, my lord. Article 120, 90 days.
Article
120 of the Limitation Act. My lord, that was the application filed by my friend.
No, there is no period of limitation. That's why I asked you.
My lord.
There is no period of limitation.
My lord, the trial court.
Read Article 120.
Yes.
Under CPC.
Yes.
Where is CPC?
My lord, this is the CPC, my lord.
Where is CPC?
No. Here the parties are not the tribal. The parties here.
Parties may be. Where is CPC?
No, CPC is applicable, my lord, in this. The trial court was Assistant Deputy Commissioner.
This suit was instituted where?
Assistant to Deputy Commissioner.
So suit is instituted in the European ward?
Yes.
Not European ward, my lord. It's outside the European ward. It is before, not in the district council court, my lord.
It's not in the district council court. Then CPC applies.
Yes, that is the issue.
Then CPC applies.
My lord, here.
And the only ground they have taken is page number 40.
Page number 40.
40, paragraph 7. May I read, my lord? They say that it is also respectful to submit that after the death of late Perta Singh Khuna Simli, there was a clash among the aforesaid clan members pertaining to the issue who represent as a plaintiff in case such and such and such. But it was renumbered 2013. And finally, the Executive Committee of the Court Assembly such by resolution 2020 had authorized your petitioner to substitute late such and such.
What is the claim in the suit?
Claim is a title disputes, my lord. What happened, my lord? His predecessor has filed a suit against me and the district council, claiming a portion in the same ship area in 1987. Now it was continued, and the original plaintiff died, and this late, my lord, Pilder Singh was substituted, and he pursued the matter.
CMLA is a name or CMLA is a position?
Well,
it's a
name.
Surname, my lord.
Yeah, surname. So
why was there in the clan?
Yes. Then he.
No, very well.
My lord, if I may just explain.
3,000 days, no.
My lord, if I may just explain. Now, my lord, here, what has happened is, my lord, this suit was instituted in the year 1987. Subsequent to that, my lord, this suit was decreed in our favor in the year 1996, which was challenged. The appellate court sent the suit back for trial to decide certain issues, my lord. Then what happened, my lord? For more than 7 to 8 years, my lord, the presiding officer was not there. The matter was never taken up. It came up in the year 2013 when the suit was renumbered. A new number was given to the suit, my lord. We were not in the know about the suit being numbered. Then subsequent to that, my lord, only in 2016, lordship, we came to know that the suit is submitted. My lord, our previous counsel was... And my lord, what had happened, my lord? We engaged a counsel who filed a separate suit in district council.
Nothing. All that is not there over here and are irrelevant.
Yes.
No, my lord, but subsequent to that, we filed another application wherein we were allowed to point out the reasons for delay in approaching the court, my lord.
So there is some other affidavit that you have filed?
My lord, there is another application, my lord, which is not been read out by my learned page. My lord, page 50.
50?
My lord. My lord, to my application for condonation of delay, a show cause was filed. My lord, in the show cause it was pointed out that I have not explained the delay. So, my lord, I filed an application craving leave of the court to allow me to explain, and which was allowed. That order was never challenged.
Where have you said anything over here?
My lord,
page 51. Nothing.
My lord, I have only, court has allowed me, my lord.
Nothing.
If lordship will see the order allowing me to explain, and subsequently, my lord, I filed an affidavit. Lordship, I will come to the affidavit once.
No, nothing. Nothing at either page 39 or at page 51.
My lord, page 58, 58. If lordship will just see once.
What is 58?
My lord, upon my application, the subsequent application, I was allowed to, by way of an affidavit, explain the reason for delay.
Reply. Who filed Miss Case number 60?
My lord, I filed Miss Case number 60, my lord.
What is Order 8, Rule 9?
My lord, I'll just... My lord, this pertains to subsequent pleadings when the court can allow subsequent pleadings, my lord. Well, Order 8, Rule 9, subsequent pleadings. No pleading subsequent to the written statement of a defendant other than by way of defense to set off or counter claim shall be presented except by the leave of the court and upon such terms as the court thinks fit. But the court may at any time require a written statement or additional written statement from any.
That's all right, yes.
So, my lord, the court had given me that leave, my lord.
Where is the impugned order?
Impugned order, my lord. That's, my lord, page number 119, ma'am. 119. Date of the order is 25th October 2022.
119.
119. By this order, trial court has allowed the application and condone it.
Just a second.
119. And judgment start from 120. 25th October 2022.
When was the application filed? Miss Case number 34, when was it filed?
34, my lord.
What is the date of filing? 8th of June 2020.
My lord, June 20. They were aware of the passing away of the plaintiff, and even they went to district council court also. And this was not.
Was the suit instituted with leave under Order 1 Rule 8?
My lord, it was a representative suit.
It was a representative suit.
It was a representative suit, my lord.
Representative suit.
That's not a bit, my lord. That's my humble submission, my lord.
In 2018.
Representative suit, no.
In 2000, my lord. I'll just point out only one.
Representative suit partakes a different character.
It's for the entire clan, my lord.
That is
partakes a different character.
My lord, here what happened is, my lord, 2011 passed away. Now they are aware among themselves. They say
may have been aware.
They went to my lord,
no.
district council court also, my lord.
No.
Can you see? In 2018,
the civil division petition is directed against an order dated October 25, 2022, by which an application for substitution of the plaintiff in a title suit, in a suit in which title in respect of an immovable property is in dispute, has been allowed after a delay of 3039 days. Full stop. It appears that title suit number 20 bracket T of 1987 was decreed in favor of the plaintiff, full stop, in appeal, the matter was remanded for reconsideration and certain specific issues were indicated, full stop. Paragraph. The suit remained pending before the court of the Assistant Deputy Commissioner full stop. the original plaintiff died in the year 2011 and it was only in June 2020 that an application for substitution was made. Full stop. Paragraph. At the outset, it needs to be recorded that there is no dispute that the provisions of the Code of Civil Procedure 1908 apply to the suit, and the suit is not pending before any district council court. Full stop. Paragraph. The suit was instituted in representative capacity. Full stop. Ordinarily, suits instituted in representative capacity are not permitted to even be withdrawn without the consent of the others, that the others whose cause is originally espoused by the eo nominee plaintiff. Full stop. Paragraph. Though the reasons proffered by the in the reasons for delay proffered in the substitution application appear to be specious, it cannot be lost sight of that the matter pertains to the rights asserted by a particular clan, and the head of the clan had instituted the suit in his name for the benefit of the entire clan. Full stop. It is equally true that it is admitted in the relevant application that internecine disputes within the clan and fights prevented a decision being taken as to who should head the clan after the demise of the original eo nominee plaintiff. Full stop. Paragraph. There are several other excuses which have been indicated by the now substituted plaintiff to explain away the delay and matters which could not have been taken into account by the trial court. Full stop. However, what is of significance is that the basis of the trial court's condonation of the delay was that the suit had been instituted in representative capacity in respect of a land claimed by the clan represented by the eo nominee plaintiff, the satisfaction recorded in the order impugned and the discretion exercised do not appear to be erroneous or perverse. Full stop. Paragraph. Accordingly, CRP so and so 33 of 2022 is dismissed with a request to the trial court to expedite the hearing of the suit and dispose of the same in accordance with law as expeditiously as the business of that court would permit, and preferably within 3 months of the receipt of a copy of this order. Paragraph. There will be no order as to cause.
Another revision petition is the 34, my lord.
Yes.
Here there is a delay of 1,964 for substitution. That order, same order, my lord. Date of the order is
Next one is same.
Same order.
In view of the order in similar circumstances passed earlier today in CRP number 33 of 2022, the present petition, CRP so and so, is dismissed. Full stop. There will be no order as to cause. Full stop. the trial court would do well to adhere to the request for expeditious conclusion of the suit as indicated in the other order. Full stop. Yes.
Obliged.
Forward. Both. No more.
Kadang ni baik.